Hi, I'm Jim Wolverton, Director of Legal Education at Kraus Financial. I'm joined today by my friend Kathleen Day-Seiter. She's also known as Kass to her friends. She's an elder law attorney in Alameda, California. She practices in elder law, estate planning, trust administration, and special needs planning. One of the most talked about topics right now in the Medicaid planning field is California's elimination of their asset test for qualification that goes into effect January of 2024. Just recently, the Centers for Medicare and Medicaid Services, the federal agency that oversees long-term care Medicaid programs, recently approved this legislation. So when I have questions, I usually try to reach out to a friend, and I reached out to Kass to get her read on what this means for her clients in the future, as well as her law practice. Thanks so much. So why don't we kind of set the table with what were I know Medi-Cal has always had different programs in the other 49 states. For those that are watching this and don't practice Medi-Cal planning, why don't you kind of set the table what the requirements were for, a high level overview of what the requirements were for someone to receive Medi-Cal benefits before I have the dates here, July 27th of 2021.
Sure. So first off, because we're California, we have to be different, and our Medicaid is called Medi-Cal. So when you can either say Medicaid, most states call it Medicaid, we call it Medi-Cal. Prior to July 1st, 2022, yeah, is 2022. That's when the law actually took effect. Prior to that, we had a resource limit of $2,000 for an individual and $3,000 for a couple. There are other income requirements as well, but the biggest thing was first, your resources were a share of cost state, so the income doesn't matter quite as much as in other states.
Absolutely. So then this bill came through and it's called Assembly Bill 133, correct? You all
Correct,
refer to that as AB 133 or something of
correct.
that nature?
AB 133.
There we go. That's what you have to know the nomenclature when you're talking to somebody from California. So what did that bill do?
Well, that made a lot of changes to Medi-Cal in general. It changed things for non or non residents. It changed things for children and families. But for our perspective, it really changed a lot when it came to the non-Magi Medi-Cal applicants. So what it did is it kind of it changed the whole resource cap. The law says in July 1st, 2022, the resource cap will go up to $130,000, but it had to have federal approval. And then the other part of the law is that it said on January 1st, 2024, there will be no resource cap. Again, it had to have federal approval.
So it went from 2000 to 130 for what, a year and a half, and then no resource cap starting January 1st of 2024.
Correct.
And so that bill was passed. It went to the governor signed it, and then it went to who approves that and how does that process work on the federal level?
So it was approved by CMS, and it was a two-step process. It approved the July 1st, 2022, a step up to 130,000. That was approved. And the second one was just approved July of this year for the January 1st, 2024. CMS approved it.
And that was the
Instead of
big top when we were at NALA in Puerto Rico earlier, the NALA annual conference. That was kind of the thing that everyone was talking about is CMS going to approve it? How are they going to do that? What's that going to look like? And then that just recently happened here in the last couple months, correct?
Correct. Correct. And I just as a side note, it's very interesting. The approval is a very short paragraph, maybe two
Yeah.
sentences.
And I'll include that as a link if anyone wants to see how short that actually is. It just says approved. So it makes all these waves. California no longer has a resource test. So as
Starting January 1st.
of January 1st, 2024, what do you see happening with qualification then? So what does that look like for someone that's looking to get nursing home Medicaid in California?
Well, So the income rules did not change at all.
Okay.
The only rule that changed was the resource cap or the lack thereof. The income, like I said, we're a share of cost state, and of course, the higher a person's income, the more they pay.
Okay.
So, for elder law attorneys, we're going to be looking at a few things. One of them is what is the income, and then of course we still want to protect the assets for recovery purposes.
Okay. So you still have some planning opportunities there.
We
And
do.
excellent. And then with the medical side, this applies to nursing home level of care, correct? This is the program that we're talking about.
Well, this is actually nursing home and community-based programs as well, because
Okay.
this is for anyone who is 65 and over, who the people who do not fit into the Affordable Care Act.
Gotcha. So when we kind of take a step back and think about what does this mean and the bigger picture, what was kind of the philosophy behind passing AB 133 on the legislative level? What was kind of the arguments that were going on there?
The argument was, this seems a little bit unfair. You're 64, almost ready to turn 65. You're on Medi-Cal because for the people on the Affordable Care Act, there was no resource cap at all. They only looked at your income. So if your income was low, would be eligible for Medi-Cal through the Affordable Care Act. But as soon as you turn 65, suddenly there was a resource cap, and they thought this doesn't seem to make sense. You're at 64, you have insurance, and at 65, you don't. So they wanted to have parity. They wanted to have it fair for those who are under 65, and for those who are 65 and over.
Okay. And I know it hasn't happened yet, and we're kind of looking into the future now with your crystal ball that you have there in your office. How do you think this will have an impact to availability of beds in facilities or any sort of quality care issues? Do you see like a big flood of people coming in because of the resource cap getting lifted?
You know, like you said, we don't really know for sure, and I think it could go a couple of ways. One, there could be a lot of Medi-Cal approved people looking to go into nursing homes. Of course, we know that most people don't want to go into a nursing home, but they usually do. It's a last resort. So it could be that the nursing facilities will say, okay, we're just going to accept that almost everybody's going to be on Medi-Cal, and we're just going to accept them. In California right now, it's very difficult to find a Medi-Cal bed in general. If you go in looking for, straight Medi-Cal already approved, it's extremely difficult. Here in California, most of the nursing homes have changed their way of admitting patients, and they only want rehab patients where insurance is paying for their stay. So they're very, very, very careful with screening patients going into their facility. They really don't want anybody where it looks like at all that they're going to stay long term, even if it's going to be private pay. Because the highest pay is going to be insurance, second highest is private pay, and then the last, of course, is Medi-Cal. So for a long time, they've been screening out. So now I'm wondering, will they be even more careful and just not take and only take younger patients who are it's pretty clear that they're going to return home? Or do they just throw their hands up and say, we're just going to take people because we know everybody's has the ability to get on Medi-Cal now? We don't really know.
Yeah. Obviously, the big question is how is California going to pay for this? Is there any sort of if we do see a big influx of folks coming into the program, has there been any talk about an increase in budget to the Medi-Cal program, or how are they going to make sure that these funds are available if there is a big surge of folks that qualify?
We don't really know yet. We do know that there is a task force out there for long-term care, a California-based task force to look at long-term care for California residents, whether they are legal residents or not. But it just started at the beginning of the year, and they're looking at a variety of things. That it could be a tax, it could be an employment tax, it could be different types of taxes, but we don't really know. There are some suggestions, but nothing has been decided. That task force is still ongoing.
Gotcha. So as we look forward again in the crystal ball that you have there in your office, what do you see as continued planning opportunities in your elder law practice? So, some people will say the sky is falling. There's not going to be elder law anymore in California. What do you see as kind of projecting out what type of work you'll be seeing as of January 1st, 2024?
Yeah, just to give a little background about why this attorneys thought the sky was falling. Here in California, even for people with quite a bit of assets, it was really very easy to qualify for Medi-Cal with some planning. We are still able to do crisis planning. So, and we have what we call stacked gifting, where in a matter of a month, sometimes maybe it's 2 or 3 months, depending on what their assets are, we can actually remove assets from a person's estate or name, and they could qualify even if they have several $1 million, strangely. So I'm not really from that perspective, it may not be that much of a difference of the number of people on Medi-Cal. I'm guessing that, of course, it will increase. But for our purposes, for attorneys doing planning, we still have a few things. One, there's the income because we have that share of cost. There's still some income planning opportunities because we have what we call the name on the check rule, which is if a check goes into, let's say it's a husband and wife, the wife is in the nursing home and she's Susie and he's Sam, the check is written to Susie, well, that's going to be considered her income. And in California, they don't look at the income for Sam, only Susie. So we want to shift that income over to Sam so that we can hopefully have fewer checks written in Susie's name.
Right.
That's one thing. Of course, we want the traditional estate planning, the power and attorney estate planning, and the advanced healthcare directive are extremely important when it comes to healthcare planning. But not only that, but the other thing is recovery. In California, our recovery is also fairly friendly towards the Medi-Cal beneficiary, in that if the only assets that will go into recovery are those that are probatable. So if it's in a trust, or if it has a joint tenancy, or if it has a beneficiary designation, uh, then it's not going to be there's not going to be a recovery on it. So we want to make sure that our clients who are on Medi-Cal in a nursing facility do not have all of their assets protected so that they won't be recovered on.
I almost asked you about the look back period, but at this point, moving forward, that's not going to be a concern.
That's correct. It won't be. Now there is a look back period still because
Okay.
we're in that $130,000
Right. Oh, as of today, but as
as
of
of today.
January 1st,
But in January 1st, it will be much different.
you won't even have to use that word anymore or that
Right,
phrase
right.
anymore.
Exactly.
What kind of community-based programs do you have there in California, and how do you think those will be impacted by this at all?
We actually we have some fairly good waiver programs, Medi-Cal waiver programs. We have the assisted living waiver program. We have a variety of programs because the goal is to keep people in their homes. And it will have the same exact requirements for the asset and the income.
Okay.
The home-based programs have a different income calculation than in the nursing facility. So, but it's going to everything else except for the resource cap stays the same. You know,
Everything else but the resource cap.
I know.
I love it.
Regarding planning opportunities, many of the elder law attorneys still do VA planning. And I also assist clients who want to have, family members going into assisted living facility and they want to review the contract and how do they navigate through public housing and all these different things because and of course there's SSI as well. So, and the rules of SSI are much different than our Medi-Cal rules. So we have to, and it's not easy to navigate those. And so sometimes, it's recommended that they seek the advice of an attorney.
Thank you so much for doing this, Cass. I think that is a really good piece of content that people will be really interested in.